Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So I want to talk today about what do you do to prepare for your deposition. You're going to sit for a deposition in front of opposing counsel and you want to know what to expect. You should meet with your attorney well in advance of the deposition. Your attorney should explain to you what the other side is going to try to prove through the deposition. What is your case about? What are the theories of your case? What is the purpose of the deposition and all of that? So let's get into it. So number one, the scope of a deposition is very broad. Under Rule 12.280, the other attorney can ask you anything that may lead to the discovery of admissible evidence, as long as it's not confidential or a trade secret or something like that. So they can't ask you anything that you and your attorney have discussed, because that's covered by attorney-client privilege or any other privilege, like a patient-therapist privilege or clergy parishioner privilege. Things like that can't ask, but it doesn't even have to be admissible for the opposing counsel to ask it. It can lead to the admissibility of evidence. Okay, so you get into the deposition, you want to know in advance, is this going to be recorded? Is it going to be taken down by a court reporter and later transcribed into a written deposition transcript? Or is it going to be videotaped deposition? So your attorney should let you know that. They should tell you, first of all, when you hear, you should listen carefully to all the questions, obviously. Opposing counsel is going to ask you probably at the beginning if you've ever had your deposition taken before, and if you haven't, they'll explain more about it, so you can't say you didn't understand. They may ask you if you're under the influence of alcohol or any type of prescription or other drug, so that it would prevent you from appreciating the significance of the questions or something like that, so you can't later try to get out of it. And then they're going to tell you the deposition is your sworn testimony, so it's taken under oath. So opposing counsel may say something like that the deposition, if you are untruthful, can be subject to perjury or something of that nature to try to unnerve you. So just stay calm, listen carefully to the questions. Next, you want to pause before you answer the question. Reason for that is you want to give your attorney an opportunity to interject an objection if the question is somehow objectionable. If you just blurt out an answer, it's already out the door. The horse is out of the barn before your attorney got a chance to object. So give your attorney a second, just pause before you answer. Next, I would say, don't speculate or guess at answers. If you don't know the answer, tell the questioner that you don't know the answer, that you'd have to either one, look at some other document to be able to find the answer to that, like a calendar or something like that. But you're not required to do that in the deposition unless the opposing counsel presents you with a document. So don't speculate, because you're going to be held to the answers that you give in the deposition. I should say here that the purpose of the deposition, opposing counsel is one, trying to discover information that may be helpful to them in the prosecution of the case or in the defense of the case. That's number one. Number two, they're trying to pin you down on your answers so you can't change your testimony when you get to trial or the subsequent hearing. So they'll know exactly what you're going to say in the hearing. And three, if you do change your answer at the hearing or the trial from what you said in the deposition, then the opposing counsel will attempt to impeach you. And that means to show that you are being untruthful in front of the court, because they'll show that your prior answer was contrary to what you're stating in the courtroom at the time of the hearing or the trial. So make sure that you understand that your attorney should get a transcript of the deposition before the hearing or before the trial, and that you should have an opportunity to review it so you know exactly what you said. You should also have an opportunity to review the transcript to make sure there's no errors in it in terms of spelling errors or grammatical errors or so forth. You can't change the deposition once it's been taken, in the sense of you can't change it substantively. Kind of in line with not speculating or guessing, if you don't want to be tied down to an answer that you're not 100% sure of, and you don't want to say, well, I'm not sure, or I don't know, you can say something like, to the best of my recollection, or sitting here today, I believe it was, or something like that, so that at the hearing, it's not a definite answer, and it will be harder for opposing counsel to impeach you because you gave kind of a qualified answer and it wasn't certain. And you can say at the hearing, hey, I said in the deposition that to the best of my recollection, or I believed it to be, but since then I've looked at something, or my recollection has been refreshed, and now I'm sure this is the answer. So that will help you. I would say don't bring notes with you to the deposition. If you've got anything in front of you, notes that you're looking at, opposing counsel is going to ask to see them, and either you're going to need to hand them over or you're going to need to put them away, because you're supposed to be testifying from your recollection, not from something that you're reading off of or referring to. So don't bring notes to the deposition. You should prepare ahead of time with your attorney so that you would not or won't need notes. This next one's kind of funny, but maybe not so funny, in the sense that I always tell my clients, don't whisper to me in the deposition. I know I'll be sitting next to you, but if you whisper to me or refer to me, the court reporter may hear it and they may take it down, or especially if it's being videotaped or recorded, it may pick up because you may have a microphone on your lapel or shirt or whatever. If you need to take a break for any reason, just say so. Whether you need to take a bathroom break or you need to just take a break because you need a breather or whatever. Oftentimes, opposing counsel, if it's in the middle of a question, they'll want you to finish your answer before you take the break. But when you are finished with your answer, you certainly are allowed to take a break, and you can talk to your attorney on the break. Your attorney is not supposed to coach you on your answers, but can help you relax, help you understand what's going on in the process, help you reduce your stress or anxiety about the deposition. Okay, so I hope that answers the questions of what is the purpose of the deposition, that it will be used later in a hearing or in a trial, that you should be careful about the answers you give, and you should be truthful. I will say that. No attorney should tell you to say anything but the truth, but you should give that pause and let your attorney object and things like that. So I hope this video has been helpful. This is Tom Marks from the Marks Law Firm and the Healthy Family Law Attorney, and I'll see you on the next video. Thanks.